Hi friends, I am Imran Ali. Today my topic of discussion is sources of law. But before moving towards the topic, let me remind you, please don't forget to like and subscribe my YouTube channel. So first of all, what is law? Law is commonly understood as a system of rules that are created and enforced through social or governmental institutions to regulate behavior. Although its precise definition is a matter of long-standing debate. The famous jurist Salman defined law as law is the body of principles recognized and applied by the state in the administration of justice. In layman's language, law means the principles and regulations established in a community by some authority and applicable to its people, whether in the form of legislation or of custom, and policies recognized and enforced by judicial decision. It has been variously described as a science and art of the justice. Introduction of the topic. The term sources of law is used in different senses. The general meaning of the word sources is origin. There is a difference of opinion among the jurists regarding the sources of law. According to C.K. Allen, agencies through which the rules of conduct acquire the character of law by becoming definite, uniform, and compulsory. Vinogradov defines as process by which the rule of law may be evolved. As per Oppenheimer, the name for a historical fact out of which the rules of conduct come into existence and acquire legal force. What are the sources of law? Laws are the rules of conduct established to maintain stability and justice in community. Laws provide ways for our society to resolve different sorts of our disputes in a very civilized way and ensure a peaceful and well-functioning society. These sources gives us an understanding of the basic and main objectives behind the formation of everything. Sources of law are the origins of rules of human conduct that came into existence in different ways. The term law is very diverse in nature. In today's world, it is very essential to have an effective legal system for the orderly function of social life and the existence of mankind. It is essential for everyone to be aware of the law of the land. One must know as to what are the sources of law and on which of the sources one can rely upon for justice. Though there are various charges and counter charges regarding the sources of law, it is obvious that in almost all societies the law has been acquired from similar sources, and generally most common sources of law are number 1 legislation, number 2 customs, number 3 judicial precedents, number 4 justice, equity and good conscience, and number 5 conventional law or international treaties. Number 1 legislation. The term legislation is derived from the Latin word legis meaning regulation and Latum which means making. The legislation is considered as a primary source of law. Legislation is that source of law which consists in the declaration of legal rules by a competent authority. Legislation is the direct source of law. Legislatures frames new laws, amends the old laws and cancel existing laws in all countries. In modern times, this is the most important source of lawmaking. It not only creates new rules of law but simultaneously it also sweeps away existing and inconvenient rules. So, legislation as one of the sources of law is further divided into two parts: supreme legislation and subordinate legislation. Supreme legislation is the parent law that originates from the sovereign strength of the nation. It cannot be repealed, annulled or managed by other legislative authority. Subordinate legislation are dependent on the supreme legislation for their validity and existence. Number 2, customs. Custom is also an important source of law. Custom signifies the habits and practices of the people. Custom gives rise to customary law. According to Salman, custom is the embodiment of those principles which have commended themselves to the national conscience as principle of justice and public utility. Keaton defines custom as rules of human actions which have been established by continuous usage and have the force of law and are applied by the courts. According to Carter, the simplest definition of custom is that it is the uniformity of conduct of all persons under like circumstances. Customs is an established mode of social behavior within a community. It is one of the main and oldest sources of law. Number 3, judicial precedents. Precedents signify past judicial decisions. Judicial precedents are an important source of law. They have enjoyed high authority at all times and in all countries. Judicial precedents lays on the doctrine of stare decisis. It simply means adhering and relying on earlier decisions made by the courts. For instance, if High Court decides on a particular case and a similar situation comes to the lower court, the lower court will treat the case alike and pass the judgment same as done by the High Court. This is because the Honorable High Court has a set precedent for the lower court and the lower courts are bound to follow it. The Dictionary of English Law defines a judicial precedent as a judgment or decision of court of law cited as an authority for deciding a similar state of fact in the same manner or on the same principle or by analogy. Precedent is more flexible than legislation and custom. Precedent plays a vital role when law is unwritten. English common law is based on precedent. Kinds of precedent are: number 1, binding precedent; number 2, persuasive precedent; number 3, original precedent; and number 4, declaratory precedent. Number 4, justice, equity, and good conscience. This principle is applied only in cases where the judges feel that the law seems to be inadequate or out of date or unjust. In such cases, the judges make decisions based on equity, good conscience, fairness, and justice using their common sense. Number 5, conventional law or international treaties. International conventions are treaties or agreements between countries. International convention is often used interchangeably with terms like international treaty, international agreement, compact, or contract between states or countries. Such laws are made by the way of treaties, agreement, etc. And these are harmonized by the United Nations. Countries who are members of the UNO have to accept such rules or norms laid down by the organization. Conclusion: in order to interpret any law, it is important to understand the source of the law. This is why the topic of sources of law has received much attention from several jurists, thinkers, and legal theorists. The most widely accepted source of law is legislation. The position of customs, the most important source of law in ancient time, has been reduced to a traditional one in the modern times. With the growing popularity of idea of constitutionalism, legislations and precedents occupy the center position among all the various sources of law. So that's all for today. I hope you will like this video and find it beneficial in your academic studies. If you have any sort of questions and queries in your mind, please comment below and don't forget to like and subscribe my YouTube channel for more informative videos.